Okay, good news, not each type, but you might want to handle certain types of assets in one kind of planning document and other types of assets in a different type. Okay. What liabilities do you have? Do you have a mortgage? Do you have loans, insurance premiums? I think everybody has taxes. Maybe you don't pay taxes, maybe your income and you have things set in a way that you don't pay any. I doubt it. Even Warren Buffett pays some taxes. Right? Medical bills. What else? What other liabilities do you have? I bet you have maintenance fees, sometimes assessments, utilities, phone, cable, internet, auto, boat, RV registrations, things like that. And then the question to ask is, how will someone else manage these assets and liabilities if you're not able? And to some extent, this may also include your spouse. Does somebody else receive your Social Security, your pension, your retirement, your investment income? I doubt it. I imagine that either you get a check or a direct deposit to your account. But could they cash the checks, access the accounts, or change your address or your bank if needed, if need be? If they're not on the account, they probably can't. And however you have this set up, you want to ask yourself, is it a good idea to have it set up the way that you did? For example, is somebody else listed on your bank and investment accounts, and is that a good idea? Now, your mind probably goes to, she doesn't want somebody to take my money, and I don't want somebody to take your money. In fact, yesterday, Hugh, my assistant, said to me yesterday, he said, "You're really protective of people's stuff, aren't you?" And I said, "Absolutely. Absolutely. Part of my job is to anticipate what might happen and make sure that it either does or doesn't, depending upon whether you want it or don't want it." But, so that's one reason to ask yourself, is it a good idea to have somebody else on your retirement checks, on your bank accounts? But let me tell you another reason to ask that question. And I'm going to cover this a little bit more later, but for almost all bank accounts and different types of accounts, if you have two people on them, both people own that account. One person could take it all, but here's the other thing. If you pass away, the other person gets that account, no matter what the will says. So many people will place a child, one child, on a bank account or on an asset title for convenience sake. And in some sense, that's a good idea. But what happens is, if you pass away, that one child gets it all. Now, if that's not what you want, don't do that. And you can say you trust people. I suggest that's not a good idea. And even if they're wonderful people, loving, with very high integrity, it isn't easy to now go splitting up assets, because now you're dealing with the gift issues and potentially gift tax, potentially, complications of what you do with these assets if it's left to only one person, and that person then has to split them up. And if they have to split them up, I don't know, I'm going by my family, okay? You're likely to have people disagree. So, yeah, ask yourself that. How will someone else manage your assets and liabilities? Is somebody authorized to access and change your insurance, if that needs to be done? Is anybody else on the deed to your properties? Very important, the difference between a tenancy in common, which most people don't have, or a joint and survivorship deed. If two people, if you're married and you're on a deed, if one spouse passes away, the property goes to the other. There's no way to get around that, and the Florida homestead provisions in the Constitution pretty much require it anyway, at least a life estate to your spouse. But if you're not married, then you have to be thinking about who truly is on your deed. Is anybody else on the title to your cars and your boat or your RV? Who has access to your safety deposit box or your safe? Who has possession or access to your jewelry, your art, and your valuable personal property? And who can pay your bills and your taxes if you can't? You want to ask yourself those questions. How are they going to manage this? And very, very importantly, and I know that's important for all of you, who will take care of the people you love? Your spouse, your children, perhaps your stepchildren, if you're not able. And what will happen to them if you can't manage your assets and liabilities? Now I want to talk a little bit about different types of life planning. And there are some things to think about. The first thing that we all tend to do but we don't think about is the title to our assets. And what that means is that's the people who are named. The people who are named on the title to the car, the people who are on the deed, the people who are on the bank account, all of that. Right? Most of the time, as I said, and there are some exceptions, but most of the time when two people are, quote, on title, they both own it, and it goes to the person who survives no matter what the will says. Most of these things pass outside the will according to the title, and there's really not anything that can be done about it. So if the way your assets are titled is not the way you want them to pass, and not the way you want them to be handled, if you can't do it yourself, you either need to change your asset title or engage in a different type of planning. So what's one type of planning? Well, power of attorney is a certain type of planning. I am a big fan of powers of attorney. I think probably everybody, every financial planner, every accountant, every lawyer, every elder law attorney is a fan of powers of attorney. However, there are some things to know about a power of attorney. Florida just last year passed a statute dealing with powers of attorney, and that it was effective in November of 2011. So all the laws about powers of attorney really came into focus, I want to say, in Florida at that time. And some people could say they became much more complex. In a way, they did become much more complex. Perhaps in a good way, and perhaps not. The big thing about powers of attorney, and I think that the real impetus behind the statute, was the banks. The banks didn't want liability for dealing with people's powers of attorney. So they wanted things to be clear, and they wanted them to be reliable. And there's still provisions in the statute that would allow a bank to refuse to honor your power of attorney. And then you got to get into an issue about it. So powers of attorney that were executed prior to November of 2011 are effective. It didn't invalidate anything that was done. However, you really should look at your power of attorney and make certain that it includes the power to do everything you want that person to be able to do. And we'll talk a little bit about this now. But it's very flexible, a power of attorney, and it allows the agent to do anything that the principal could do, so long as the power says they can. So for example, if the power of attorney says that your agent can give gifts, they can give your property away. If the power of attorney says that your agent can disclaim your right to inherit from something, then they can. If the power of attorney says that your agent can deal with your insurance policies, then they can change the beneficiary on your insurance policies. If it says that they can manage your bank accounts, they can do everything with your bank accounts. Same with investment accounts, etc. Now, is that important? Yes. And so my advice is, don't make anybody your agent on a power of attorney unless you truly trust them. Now, the statute provides for accountability for the person who's the agent, and a power of attorney is not a license to steal, but I spent many, many years in litigation. You don't want to go there. It won't turn out well. And I don't care how clear the conduct. Litigation is long, it's expensive, it's difficult, and you don't want to do it if you don't have to. So a little bit of thinking ahead of time is a good thing. Here's something you can do with a power of attorney, and that is you can execute one and either keep the original yourself. You can put it in your safety deposit box, you can put it in your safe, you can leave it with your lawyer, and provide that it be given to your agent when it's necessary and not before. Or you can give it to the agent right away. There used to be something called a springing power of attorney in Florida, which is a power of attorney that became effective only when you became disabled. That is now invalid. If you had a springing power of attorney, I don't think your power of attorney is valid. I'd have to look at that, but you can't write one now, that's for sure. So you can only write a power of attorney that's effective now. If you think about that, the banks, how are the banks going to figure out that you're disabled? When somebody shows up with the power of attorney and says, I want to clean out my mom's account. They can't, which is one of the reasons that a springing power of attorney is no longer valid. It's impossible to police. It's impossible to know if it's truly valid. So they're effective immediately, right? So if the agent has it in his or her possession, he or she can use it. Now, importantly, a power of attorney expires when we die. So once we're gone, the power of attorney is of no use. It is not an avoid probate kind of document. A power of attorney is a manage my affairs for me, either for convenience or because I can't kind of device. Now, power of attorney is almost always needed. Even if you have people listed on your assets, your bank accounts, usually that person can't stop or start payments from Social Security or from a retirement account or from an annuity. They can manage it once it gets in your bank account if they're on the account, but they can't handle what comes into the account. Even if they're listed on a deed or a title, they can't sell that property without your signature unless they have a power of attorney. A beneficiary of an insurance policy can't cash the insurance policy in, they can't sell it, they can't change it. Right? Without a power of attorney, they can't legally sell your car or your boat or your RV. Right? So a power of attorney is almost always needed, even if you have carefully titled your assets and if you have a trust.